Hello and good morning from the Permanent Bureau of the Hague Conference on Private International Law, the HCCH. I would like to welcome you and to extend my appreciation for everyone participating in this initiative, the HCCH CBDCs Colloquium, which is also the 2023 edition of our CODIFI series of events and programming. In the inaugural HCCH Conference on Commercial, Digital and Financial Law Across Borders, the CODIFI Conference of 2022, experts concluded that further study of the private international law aspects of central bank digital currencies is both timely and desirable. In acknowledgement of this input, the HCCH Council on General Affairs and Policy, CGAP, at its 2023 meeting, mandated the Permanent Bureau to study the private international law implications of CBDCs in partnership with relevant subject matter experts and observers, and to organize an online colloquium on this subject. Earlier this year, after the Permanent Bureau obtained this mandate, the organization's members had the opportunity to nominate experts to contribute to this project. In particular, a kick-off meeting was held in July in order to gather the experts to discuss a scope paper, setting out fundamental questions regarding the topics and issues that this project should explore. Experts have, in the past months, engaged with these questions by providing the PB with written analysis and producing video presentations addressing matters of particular interest. Those video presentations will form the first half of the program today. They will be broadcast according to the order they are listed in the colloquium agenda. For those who are not able to follow this live stream through the day, most of the videos will also be made available on the HCCH YouTube channel following this event. Now, before turning to the main contents of the day, let me briefly describe some of the main private international law questions that have arisen in the foundational document for this project. You find it in preliminary document 3B of 2023 before our council. And this is the scope paper as well that we will be speaking about on this project. CBDCs at its simplest level are digital currencies issued by central banks, as its name suggests. These have been capturing attention around the world for their potential as a new form of money, with several policy benefits having been proposed or identified. Central banks worldwide are in various stages of testing, sandboxing, piloting, and circulating CBDCs. In light of the diverse approaches being explored, a primary matter concerns identification, characterization, and taxonomy building of current practice among jurisdictions in both technical and legal terms. Specifically, do CBDCs qualify as money, as near money instruments, or as legal tender, or are they a distinct notion? Is it an object of proprietary rights? Can they create monetary obligations? In reference to each legal characterization, connecting factors in determining the applicable law could be explored. Depending on the chosen model of operation, particularly in relation to cross-border CBDC access by non-residents, central banks may delegate functions to private sector intermediaries, raising further questions about the roles of custodians and other services that may be provided for the circulation of CBDCs. We are thrilled to have in this colloquium a number of distinguished experts from the CBDCs project, as well as others invited by the Permanent Bureau to help begin to explore these challenging questions. The Permanent Bureau will report to our Council on General Affairs and Policy at its 2024 meeting on the outcomes of the study, including a summary of inputs from today's colloquium. In closing, allow me once again to extend my appreciation to all the experts involved in this project, and I hope that you joining us around the world enjoy today's broadcast. Thank you.